been involved in. And listen, it's such a standard part of working in the blogging and media world. Unfortunately, I would think of it as sort of an occupational hazard. I have been targeted frequently by some people that I think are just like up to really not so good things. And so sometimes those people don't like me reporting on them. But one thing that we've been trying to prove to the court in all of these, because there's been a series of them, is that I'm a journalist and I should qualify what's called journalistic privilege in the state of Minnesota. And yesterday, a judge actually said that I was. So they said defendants are plausibly a journalistic outlet which enjoys a qualified privilege against defamation claims.
Plausibly, not probably, plausibly.
Basically meaning like I'm doing a job and I have a privilege to do my job. And you can't just sue me because I've done my job. Also,
really? Okay. I want to address this a little bit more. I did a reading already once discussing this, and this is the post that I read from. I want to point out here to the left. She's quoting an article from The Balance, and in the article, they're quoting Ben Michael, an attorney with Austin-based Michael & Associates, in which Ben Michael states, qualified privilege is often used as a defense in defamation lawsuits because it essentially offers immunity. And it can be used as a defense if the person who made the statement can prove that they did so without actual malice and or out of legal moral duty. If the statement was made in good faith, then actual malice cannot be proven. Now, I went and I found this article. Let me share this with you, because this is the part that Katie just conveniently left out of her post and everything else in which she talked about this on. So here we have, here's The Balance. See, as you see, this is the article in which she quoted from. Now, if you scroll up to the top here, what the article is actually about. Qualified privilege in a defamation lawsuit is a type of defense in which a statement made by the defendant is not considered defamatory in certain situations when no malice is involved. It's often used by employers when acting as a reference for former employees. This is what this article is about. It's speaking about this coming from the place of employment and giving referrals and such, and the things that future and or past employers may state as a result, and whether or not they can be sued over this. This is what this is using this law to apply to. So this is what Ben Michaels was commenting on. I want to keep going though, because this is still quite interesting. Because even here it says qualified privilege is often used as a defense for employers sued after giving a negative reference for a former employee. And it goes on to explain, the generalistic kind of application and everything. But then it goes, and here's the part where Ben Michaels quotes, okay? And this comes from here. There must be a clear reason why the statement was made. It's all, this whole thing is about right here. Some states such as Florida have laws that provide qualified immunity from liability for giving a truthful job reference in good faith. This is all about what employers do and say as a reference about someone. Now, but I want to address this a little bit further, a little bit deeper. So let me share this with you as well. Now, upon my looking for that article, I came across this that I thought was quite interesting. This goes on to talk more about the privilege defense in a defamation case. This isn't at all strictly from, or primarily from, an employment standpoint. This is just generally speaking. So it says, in some cases, the person making a defamatory statement may be protected from a civil claim because they had a right to make the statement. Okay, and it goes on and it talks about more of this, but then it goes and breaks them up. Okay, there's absolute privilege, and there's two kinds of this privilege. First is absolute privilege, and that is if a statement is absolutely privileged, it cannot be made the basis for a defamation claim. For instance, if a person is offering testimony as a witness in court and gives damaging testimony about someone else, such as that person lied or cheated, those statements will be protected from civil liability for defamation. This is because the government wants to encourage people to testify openly and honestly. And another example of absolute privilege is someone who's a court-reported or court-mandated reporter, and then they see something and they're they're obligated to report it, and they do so, but that report ends up just being wrong, or there was no reason. It turned out to be no reason for a report, but at the time that mandated reporter believed that they were obligated to report, they would also be protected under absolute privilege. Okay, Katie is neither of these things, neither a witness in a court of law, nor is she a mandated reporter. But okay, it's absolute privilege. Now qualified privilege in defamation cases, which is exactly what she's trying to claim here. Qualified privileges are slightly more complicated. A qualified privilege may apply to subject matter that is of public concern or is of sufficient importance that communicating freely is critical. For example, a newspaper reporter may claim a qualified privilege for reporting on official government business. The policy behind the privilege is that openness and transparency is desirable when it comes to issues of public importance, and the media should not be hindered from reporting on or discussing such issues. But we're not talking about any kind of official government business there. We're not even talking about anything that's really of public importance or anything. So I don't see how this would apply to her. Like, this wasn't even a big group that she was defaming, or many people. This was like less than 20 people. Anyway. Criminal activity. For example, arrest records are usually reprinted in the newspaper, and articles are routinely written about local criminal cases. Sure. And because of the significant public concerns wrapped up in this kind of information, such reporting, if done fairly and accurately and with verifiable sources, is privileged. Okay, sure. Arrest records. Yes. Criminal cases, actions made or statements said in a court of law. Sure. But accusations without any kind of conviction or judgment regarding these accusations would not apply here, because that's just gossip, really, right? Anyway, employment information. Another context in which qualified privilege arises would be the employment setting. For example, if a former employee is asked about you by a potential employer or a workers' compensation carrier, he or she may claim a qualified privilege if the information they are asked to relate is less than positive. While this is beyond the arena of public concern, there's still a policy in play here that wants to encourage the speaker to provide a complete and accurate picture of the information being sought. Well, no one was looking to employ Robert Chin, so okay. Claiming qualified privilege. To successfully claim a qualified privilege in many jurisdictions, the speaker must have made the statement in an appropriate situation. And for example, newspaper coverage or reference request. There was no reference request, and this was not newspaper coverage. This was a gossip blogger who's self-appointed, self-run, self-owned YouTube channel. That's it. Anyway, for a reasonable purpose, for example, providing fair and accurate information, these figures were not even discussed about in any way, shape, or form publicly. So, not sure where that applies. Like, the only reason why anyone really has heard of these people is because Katie herself started saying the shit that she said about them. And with reasonable cause, for example, based on knowledge gained from investigative journalism or from working with the person. She did not work with Robert Shin. Oh, no. First of all, they said and with reasonable cause. And, okay, so that means in addition to. So even if this were true, it doesn't include the first part that's required to make this an and. If the statement was made maliciously, for example, if the plaintiff can show that it was not made with a reasonable purpose or with reasonable cause, or that the speaker made the statement knowing it was false, or with a reckless disregard for the truth, it will not be protected by a qualified privilege. Now, as you recall, even according to Katie's words there, she didn't say that she has been granted this immunity. She said that the judge said it's plausible. So it has not been applied yet. It is not yet applicable because it has not been ruled as such. It's just plausible, something to consider. It could be. And also remember, the judge all the judge knows about Katie and 7M and all that transpired between the two is what each side of this lawsuit has put forward. The judge cannot go and investigate shit on her own. She can't look to other places or sources for information. She's only ruling on the basis and merits of this case, not on the entire situation as a whole. Unless it's discussed, mentioned, and brought up for her attention in court, it doesn't apply. So we have to remember that all the judge knows regarding the two parties is what's been said in either complaint. And even that, that's all that she's heard or been made aware of. This isn't anything that she's known or she's taking as fact, because discovery is yet to still happen, let alone be put forth in the court. So all she knows is what each side is alleging. That's it. That's all she knows. So for her to say it's plausible makes perfect sense, actually, because when she does get more of the facts and when discovery requests are finally fulfilled, and I imagine that 7M side will now be asking Katie for her journalistic qualifications, to which there are none, the judge may have a difference of opinion. I think that it's more than logical that the judge could very well have a difference of opinion regarding this whole journalistic qualified privilege. Yeah. Anyway. Oh, that's it. That was the end of that article. That's right. Right. Okay. So yeah. Once again, Katie Joy reads something or hears something, imagines it's saying something else, and she runs with it as though it's fact. This is when shit gets interesting. When she's feeling so overly confident and emboldened that she feels as though she has these outside sources accrediting her. This is when she royally fucks up. I'd stay tuned if I were you.